Day. And today we have with us Senior Advocate Aditya Sondhi sir. First, I would like to tell you about Just Corpus. Just Corpus is a body of legal professionals who have come together to incorporate an interdisciplinary journal, the Just Corpus Law Journal, an edtech platform set up in 2020, having 600,000 clicks per month on an average basis. Just Corpus is a quarterly double-blind peer-reviewed e-journal that is open to students, academicians, scholars, and professionals in the law profession and allied fields to publish and read the content which is published in the form of articles, blog, case comment, research articles, etc. Just Corpus has published more than 600 manuscripts from 7 different countries. It was also featured in top 100 legal blogs in India by Feedpost. Just Corpus is one of the highest indexed law journals in India, having major indexings at Heen Online, Manupatra, and JGate, etc. It is one of the very first Indian journals listed in Heen Online without any institutional affiliations. Apart from publication, Just Corpus also offers online internship opportunities to law students as content creators and editors. Today, we have with us Dr. Aditya Sondhi sir to deliver a lecture on Supreme Court decision in Vidarbha Industries return to the pre-IBC era. Dr. Aditya Sondhi is a senior advocate practicing before the High Court of Karnataka and the Supreme Court of India. Sir also served as the Additional Advocate General of Karnataka from 2016 to 2018 and has been appointed as amicus curiae in several matters of public importance, including speedy disposal of criminal cases against members of parliament and state legislatures, implementation of the Right to Education Act, upkeep of infrastructure and removal of encroachment in the city of Bengaluru, and health and safety of workers in a coal-fired thermal power plant. Sir was also recommended by the Supreme Court of India Collegium for elevation as a judge of the Karnataka High Court in February 2021. Sir holds a master's in political science and was awarded PhD by Mysore University for thesis on the interface between the army and the democracy, India and Pakistan compared. Sir has delivered lectures widely in India and abroad and has published 2 works of non-fiction with Penguin India. Sir also taught constitutional law, professional ethics, corporate law, and arbitration at the National Law School of India University, of which he is a graduate. Sir, personally, I've been watching your videos on YouTube and reading your arguments on various news portals. It's a pleasure to host you today. Over to you, sir.
Thank you, Amarpal and Ayush, for the introduction and the invitation. And congratulations on the good work that you do. It's an interesting topic that you've chosen, which is the judgment in Vidarbha, a return to the pre-IBC era. And I was the one who asked you to place a question mark at the end, because the topic would have otherwise suggested that it is indeed a return to the pre-IBC era. That question mark is not accidental. It has been placed because there are 2-3 questions that arise from the topic itself before you go to the judgment. What was the pre-IBC era that the IBC has sought to substitute? Is that necessarily for the better? Does this judgment lead to a reversion in the jurisprudence of insolvency? And is there some value judgment that is being made that the IBC is the solution to the ills of the Companies Act 1956, under which the winding up of companies used to take place, what is now known as insolvency or bankruptcy? And these questions are at the center of this topic, and unless we address them, analyzing this judgment in isolation would really not take us very far. We will analyze it, but first one or two introductory comments. What was the pre-IBC era? I have practiced on the company side for over 20 years. In fact, when I started my career, it was predominantly before the company court being the High Court concerned. And the matters basically ranged from winding up under Section 433E and F of the Companies Act to some schemes of revival under Section 391, schemes of amalgamation under 394, the backlog or the old cases of oppression and mismanagement which had not yet been shifted to the Company Law Board. And necessarily, if you practiced on the company side, then you also appeared before the Company Law Board, which heard the post-amendment oppression and mismanagement rectification cases, etc., under the Companies Act. It is this gamut of litigation, coupled also with the jurisdiction that was exercised earlier under the Sikh Industries Act, etc., that has been amalgamated and brought under this IBC. Now, yes, it is a step forward in the sense that it consolidates the law. It has slight improvements when it comes to provisions relating to the insolvency process. At least in theory it does. How it's working is a different question. And its intent is to expedite the process and to ensure that the financial creditors or the operational creditors, as the case may be, are able to recover their dues, and that importantly, companies don't necessarily slip into insolvency in all cases or liquidation in all cases. And in cases where there is scope for rehabilitation, the insolvency professional invites applications from the applicants who can look at reviving the company by paying off the creditors and bringing back the company to its original steam. Now, all that in principle is, of course, welcome. But when you say pre-IBC era, what is it that Vidarbha does that makes us question whether we are reverting to the pre-IBC era? There are two, three broad things I will flag before going into this judgment, which I would say was to the advantage of the pre-IBC era. One is that those cases were not heard by the tribunal, but were heard by the High Court. And this will take us into a debate regarding tribunalization. I don't intend to digress, except to say that some of the finest judges I have had the privilege to appear before were the company judges in the High Court of Karnataka, and they have gone on to be illustrious chief justices and judges of the Supreme Court. The other thing is that there was a robust balance between protecting the interests of the creditors and in sharp cases where companies were plainly unable to pay their debts to pushing them into winding up. And in cases where they showed signs of rehabilitation, give them ample opportunity to do so. The Companies Act may not have had the strict checklist kind of provisions that the IBC provides, but I believe that the discretion exercised by the High Courts acting as the company courts often brought about this balance between the two. Yes, the marked difference was the old act had the liquidator who carried out the last rites of the company, as it were. And now that has been substituted by what is meant to be a more professional insolvency process done through the RPs. These two or three things that I've said, the approach of the courts, the fact that it was before the High Court and not necessarily before the tribunal, and the rich body of precedents under the Companies Act, according to me, made for a good body of work in company law jurisprudence to work with insolvency. I don't want this lecture today to become about whether the IBC is better or the old Companies Act was better. That's not the topic. But since this question has been framed, that does this judgment revert us to the pre-IBC era, I would like to first begin by saying it is not a necessary truism that everything under the IBC is kosher and everything that existed pre-IBC was miserable. Please dispel that impression if you had it. If you read judgments under the old act, or you discuss the provisions with people who have practiced under both the regimes of law, you will find that there are strengths and weaknesses in both. Now, that said, let us look at this judgment in Vidarbha itself. To understand or critique it, let's understand the basic facts that arose in that case. Axis Bank, as the financial creditor, brought a petition under Section 9 of the Insolvency Code for breach or default in payment by Vidarbha, who was the debtor. The amount claimed was somewhere in the range of 500 crores. Obviously, Axis Bank was a financial creditor, though from the facts of this case, it appears it was acting standalone and not necessarily as the lead bank of the consortium. I don't think that makes much difference. Now, in these proceedings, the petition was filed and Vidarbha made an application to defer the adjudication of the proceedings by the NCLT Mumbai. It did not seriously dispute the default, and it would be difficult to dispute a default with a financial creditor or a bank. After all, if you're due, you're due. But the request by Vidarbha for deferment was on the ground that it was allegedly entitled to over 1,000 crores, somewhere in the range of 1,400 crores or so, as additional fuel costs. These fuel costs that it claimed were on the basis of a judgment delivered by the APTEL, which gave it the benefit of this revision, as a result of which it was, basis this judgment of APTEL, on paper at least, entitled to claim this amount of 1,400 crores or so, not from Axis Bank. Let's be clear. That was a claim that it had on account of this revision statutorily provided by APTEL. Aggrieved by this judgment of APTEL, the MERC, that is the Maharashtra Electricity Regulatory Commission, preferred an SLP in the Supreme Court, and that SLP was pending. Now, according to Vidarbha, the question of its entitlement pursuant to the APTEL judgment was sub judice in the Supreme Court, and a result of that, according to Vidarbha, meant that it was, at least on paper, entitled to 1,400 odd crores towards these additional fuel costs. Should those 1,400 odd crores come to its books after the Supreme Court disposes the case, it would be in a position to not only pay off the lesser claim of Axis Bank, which was in the range of about 500 crores, but also be able to rehabilitate itself. But the point to be noted here is twofold. One is, this was not a counterclaim or a claim that the corporate debtor was making against the financial creditor. It was a third-party claim. Secondly, the facts of Vidarbha do not make it clear whether the Supreme Court had stayed the order of APTEL or not. So, in toto, this was really in the nature of an award or an order or an amount that was receivable by the corporate debtor as a decretal amount or an amount basis in a order of a quasi-judicial body. Now, this is nothing new. It so happens that in this case, Vidarbha was entitled to some fuel costs because it was APTEL. It is practically no different from saying that a corporate debtor has an arbitral award, let us say, for 1,400 crores from an arbitral tribunal, and that recovery is pending because of a stay, say, in a Section 34 petition before the district court, right? It's money receivable, but not yet received. It's an actionable claim subject to the outcome of a separate list. It's not even money in the bank. I want to make this point very clear. It's not that this 1400 crores was sitting in the books of Vidarbha as the corporate debtor, but it was unable to utilize this amount. This was money it claimed to be receivable. The second thing is, was there a stay in the SLP against the order of APTEL or not? Let's test it either ways, because really that's not an issue related to insolvency. If there was a stay, that amount was not payable, at least in the interregnum. It was then for Vidarbha to have that stay vacated, with which, frankly, Axis Bank as the creditor is least concerned. If there was no stay, let us presume, then the order of APTEL was enforceable in a manner known to law under the Electricity Act and the attendant regulations, in which case, if there was no stay, then Vidarbha should have executed it. So either which way, the rights of the corporate debtor to receive this amount of 1400 odd crores was not crystallized. It required either an order from the Supreme Court in the SLP that was pending. Just give me 1 second. I'm sorry, there was some disturbance. So either which way, this amount was not crystallized as being final. It would have required Vidarbha to move the Supreme Court for appropriate orders, or maybe even a direction to release this amount so as to save it from insolvency. And remember the difference, that would have been a jurisdiction that the Supreme Court would have been exercising under 142, read with 136. This was a case that went up to the Supreme Court against the order of the NCLAT. Both the NCLT and NCLAT rejected the application of Vidarbha, saying, look, there is no question of giving you a deferment because you say some amount is due to you from a result of the APTEL order that may or may not come. And as I said, it's practically no different from a decree or an award that a debtor may hold, but has yet to be is yet to be enforced. In the SLP against these two orders, the Supreme Court in the Vidarbha case that we're discussing took a different view, reversing both these orders, holding inter alia a couple of things which I believe need quite a bit of discussion, though not necessarily in the context of whether it reverts you to the old act or not. The first thing the Supreme Court said is that the word may in section 7 of the code, that the tribunal may admit a petition for insolvency, is really in the nature of discretion. And if it is discretion, that discretion could be exercised in favor of the corporate debtor also to enable it to rehabilitate itself. Let's first test this proposition. Yes, it is true that section 7.5 uses the word may, but 7.5 is also circumscribed by the criteria laid down therein, which is, has there been a default in the amount due to the financial creditor, or is there a defect in the application, or is there some disqualification of the resolution professional? We are not concerned with 2 or 3. So the question is there a default? And remember, this is a petition by a financial creditor. Now, if there is a default, the writing is on the wall. In those circumstances, may is practically shall, because there is really very little else to be done. Yes, the Supreme Court is right in Vidarbha in saying that the NCLT must keep an eye on the ability of a corporate debtor to possibly rehabilitate itself, revive itself, and not slip into ultimate liquidation. But that jurisdiction is not exercised at the time of admission. That jurisdiction is to be exercised in the process of the appointment of the insolvency professional and the actual insolvency CIRP, the resolution process, where, if feasible, with the approval of the committee of creditors, if there is a revival plan which is feasible, that plan can be sanctioned. On the other hand, if it is obvious that there is no way to rehabilitate this company, I'm afraid it has to slip into insolvency. Now, by placing this, I would say, additional discretion in the NCLT by reading the word may in 7.5 to mean taking into account the ability of a company to revive itself, I think in some ways section 7 has been rewritten. It is not pre-IBC, it may be post-IBC, maybe something new. Is it pre or post? Besides the point. The point is, in my very respectful understanding of the law, that takes things beyond what the NCLT is supposed to look at in a section 7 application or petition, especially at the stage of admission. Now, the second thing is the contrast that the Supreme Court made with section 9.5. It's an interesting contrast because that deals with an application or a petition by a operational creditor. And under 9.5, the word used is shall admit. Now, this is an interesting question for all of you. When two parts of the same enactment, one uses the word may, the other uses the word shall, an interesting principle of statutory interpretation arises, and it is no doubt correct that the Supreme Court and the High Courts have repeatedly said that if may is used in one provision and soon after shall is used, and there is some pari materia between the provisions, there is a comparison that can be made, then in that case, one has to assume that legislature deliberately used the word may to mean may and shall to mean shall. In other words, as directory and mandatory. To that extent, the Supreme Court is correct in Vidarbha in making this contrast. But the distinction is that under 9.5, the word shall is not mandatory in the sense that the NCLT has no discretion there. And that is where I think, again, Vidarbha may have missed the finer nuance of the code. 9.5 says, yes, the NCLT shall admit, but not shall admit for the asking. It shall admit in the circumstances set out therein, one of which is whether there is a notice of dispute or otherwise a record of a dispute raised by the corporate debtor. I believe this is crucial. It is crucial because we are dealing with two different species here. Section 7 is a financial creditor. 9 is an operational creditor. This distinction per se was not there under the old Act, though it was developed through case law. Now, what the Act does here is consciously treats financial creditors, which is really in the nature of people who lend, ordinarily banks and financial institutions, treats those lenders as financial creditors and creates a special mechanism for them under 7. Then comes the operational creditors, who are basically those who in the course of trade supply goods or services and who have unpaid invoices. This is a separate category. Purely the intent of the code was not to elevate the operational creditor higher than the financial creditor. That was not the intent. That is not even pre-IBC. This is why I said we need to test this pre-IBC issue. Pre-IBC, a financial creditor or a secured creditor, let me be clear, not all financial creditors are secured creditors. A secured creditor is one who has a secured debt as against an ascertainable or a identifiable property of the corporate debtor, which is registered in a manner prescribed under the old Act. But once you meet that threshold of being a secured creditor as a bank or a financial institution, you could be a state financial corporation, you could be any other lender, you could be a public sector bank, you could be a private bank. Once you were a secured creditor under section 529A, remember I'm talking about pre-IBC, old Act, you had an elevated status. You had an overriding right to recover or receive payment under 529A alongside workmen. I think that was a very interesting statutory innovation. It treated by a deeming provision workmen rightly out of a social obligation of the law, treated workmen on par with secured creditors. I think it's very rare in corporate jurisprudence to find that a secured creditor who may be due maybe sometimes hundreds of crores, and a workman, an individual workman may be due sometimes a few thousands as arrear of salary, but put together, the workforce are treated on par. And what was the intent there? To treat A, secured creditors superior to unsecured creditors, what we can now loosely say are operational creditors or such financial creditors with no security, and also treat workmen, though not secured otherwise, on par and give them an overriding right. And which meant when the liquidator sold the assets of the company in liquidation, the first payment would go to them, pro rata, overriding, not non-obstante clause. And only if they were discharged in full, which was very rare in my experience. I've hardly seen cases where secured creditors have been paid in full. If you can pay them in full, why go into winding up at all? You might as well pull yourself back and run. And if something was saved, then that would be distributed pro rata in turn to the unsecured creditors. Even the government, who may have tax claims, would wait in the queue after secured creditors. So again, friends, pre-IBC era, not everything was wrong. Now, what this judgment does is, it says because 9(5) uses the word shall, that appears to be mandatory. 7(5) says may, therefore it's discretionary. Now, how is 9(5) mandatory? Let's test it. It is mandatory in a very different way. We have to see how it works. It is mandatory provided that threshold is crossed. And the crucial ingredient I told you is there should be no dispute. Notice of dispute. Of course, Supreme Court has interpreted it. And while interpreting it, let me again tell you, friends, has utilized principles that were applicable under the old Act, at least in spirit. The jurisprudence under the old Act, the Companies Act, was undisputed debts can become the basis of admission of a petition under section 433E. I'm not going into F, which is loss of substratum, just and equitable, etc. That's not germane. Now, undisputed or an admitted debt meant a debt where either the company, that is the debtor, in writing, in so many words, admitted the liability, like an acknowledgement of debt or the issuance of a check that is dishonored or something, or a memorandum of settlement or something like that. Or it meant cases where the dispute raised by the corporate debtor was not bona fide. It is only in those small exceptions where the dispute was bona fide that the debt was regarded as being disputed. So it was not a dispute for the asking, and I have seen hundreds of cases in my experience where the dispute of a debt would only get raised for the first time after a statutory notice was issued under 433E. And the test of a bona fide dispute was that dispute in existence earlier? Was there a genuine counterclaim? Was there a dispute regarding the of deficiency, say, in service, or deficiency in goods, or in construction? Or was there a genuine claim regarding bar of time or concoction of documents? Was there a claim pending? There could be cases where there was already a suit pending, or there was an arbitration pending. And in those circumstances, the court said, yes, those are cases of bona fide dispute. If not bona fide, Justice Shivshankar Bhatt, a very learned company judge of the Karnataka High Court, laid down a test somewhere in the 80s called the moonshine test. Was this moonshine? Moonshine, as you know, unlike sunshine, comes late in the day. Was the defense only shining when the notice of default was issued? If so, it was an afterthought, not bona fide. Now, these principles have been read in to 9. It's not that a corporate debtor can simply, in a reply to a notice, say, I dispute it. Everybody will dispute it then. In that case, how is 9(5) mandatory, may I ask? If there is simply a dispute, notice of dispute raised in the reply or in the pleadings, is the NCLT going to say, yes, look, there is a dispute, out you go? Obviously not. And the NCLT is then going to adjudicate whether that dispute is bona fide, is it arguable, tenable. Justice Rohington lays down those criteria in a number of judgments, Swiss ribbons, etc. And if that makes out some prima facie defense in a civil proceeding, potential civil or an actual civil proceeding, then the company can be let off. So it's not mandatory. In both ways, there is a discretion. One is to see if there is a dispute. So it's not blindly that the NCLT puts its rubber stamp and says, admit, let insolvency process start. On the other hand, it also has a discretion to see whether the dispute is arguable or bona fide, and not simply to avoid insolvency proceedings or to hoodwink insolvency proceedings. And it is only after that. Now, that does not mean that 9(5) elevates the status of an operational creditor higher than a financial. That is certainly not the intendment. The outcome of the judgment, in a sense, seems to now be that 9(5) escalates things for operational creditors and in a peculiar way puts financial creditors behind. That was not the intendment at all, though there are references in the judgment to how financial creditors have more, what should we say, institutional cushion, as it were. A bank can afford a little more delay. One of the main grounds in this case was delay, that the NCLT and the IBC, as you're all familiar, has very strict timelines built in. That is an improvement in a way to the old act, that making an application for deferment in a way is delaying proceedings, and therefore that is not the intendment of the court. Supreme Court said a financial creditor, being normally a big bank or financial institution, can take that blow. It can take that delay, doesn't really matter. But that's not the jurisprudence. We have to look at a judgment jurisprudentially. After all, it will be applied going forward. And if it is to be applied, then in every case where a corporate debtor has some money due, as I said, it's going to come before an NCLT and say, please defer it. Today, to some extent, at least, this amount was crystallized because there was an appellate judgment, though it was not final. As I said, matter was pending in Supreme Court. What if tomorrow you say, I have dues, I am an operational creditor? A debtor can also be a creditor, right? Vidarbha Industries borrowed from Axis Bank and became a debtor. Vidarbha Industries would have also done work in the market for third parties and quay them, it's a creditor. Can it then go to the NCLT or an equivalent corporate debtor go to the NCLT and say, look, sir, I have monies receivable from the market. I have done work for somebody. I have to receive 100 crores, 10,000 crores. Please defer it. I mean, then that's the same logic, isn't it? And that was not really the intendment of the act or the code. Reference was made to Rule 11 of the rules, which is the inherent power. Of course, the NCLT has inherent power, but inherent power has to be exercised keeping in mind the substantive provisions. Obviously, the NCLT has the power to defer a case in an appropriate situation, but that cannot become a principle to say that I have money receivable, therefore please adjourn it. How long? Can you say I have a suit pending? A suit may take 8 years to be decreed. Or you're going to say I have a decree, RFA appeal is pending, await the RFA. That's not solvency. And here again, friends, I want to make this point very clear. Pre-IBC was not so bad. Pre-IBC had its principles set in stone. Now, Supreme Court, while dealing with winding up matters, and I will stop shortly, I believe I have another 5 minutes. The Supreme Court, while dealing with winding up matters under the old act, said the test under 433 is commercial inability to pay, meaning thereby current assets versus current debts, not fixed assets and fixed liabilities. I think those of you who are familiar with reading a balance sheet will know the difference. There's a very profound accounting difference between a current transaction and a capital transaction. or a fixed asset transaction. A current account will show your actual cash in bank, your liquid assets. Sorry, just one second. I'm so sorry. The difference between current assets and current liabilities, cash in bank, etc., current in hand. Compare that with your current liabilities. If you are plus, you're deemed to be solvent. There's no point saying the demand made against me is for 50 lakhs by an unsecured creditor. I may not have 50 lakhs in my bank account to pay this person today, but I have fixed assets, plant and machinery of 5 crores. That is not the test of your solvency. If you have to sell your fixed assets to pay 50 lakhs, it means you're insolvent. That is exactly what a liquidator does. Sell the assets and pay. So that's not the answer. The answer is, do you have the current liquidity to be able to repay? And the judgment used to be called pickup. It was the PIC UP, Uttar Pradesh Corporation, Industrial Corporation UP, colloquially called the pickup case. The Supreme Court said ultimately, even with your current solvency, that is your ability to pay an immediate debt, prove it, pay it. It's like calling your bluff. If you're solvent, show the money, put it down. Supposing you say there is a dispute, so many judges used to say very well, you say there is a dispute for the respondent, Mr. Sondhi, ask your client to deposit the money or to give a guarantee. That shows your solvency also. Or simply pay it. There's no point in saying, I have money in the bank. I have money not just in the bank. I have money by way of fixed deposits. I may have to break FDs. I own plants, assets, buildings, factories. No, that's not the test of commercial insolvency, which is to be understood from a realistic commercial sense. And that is why this judgment also, I believe, may be revisited on this doctrine as well, as to what is ultimately the onus on a corporate debtor to demonstrate before the NCLT. It's not good enough to say there's some money far away, illusory. No, you ought to be able to show that willingness to borrow from a specific performance analogy. You have to be able to show that readiness and willingness to discharge this debt, subject to any disputes that you may have. And if that money, unfortunately, is not in the bank, in hand, then in that case, you can't give a carte blanche to a debtor to say, yes, we will defer proceedings till such time you go to town to recover it from third parties. No, because then financial creditors are frustrated, and that's not the ethic behind the IBC. That was not the object behind which the IBC was formulated. Financial creditors deal with public money. There is a larger economic interest in financial creditors receiving their money. It's not to say operational creditors should not. As we know, many times operational creditors can also be MSMEs. They need their support, but then they have an act. And recently, Supreme Court has said MSME prevails even over arbitration act. But they have their own interests, but in a macroeconomic sense, financial creditors need their money. So you can't say I have 30,000 crores due as a bank. Let's say this was the Kingfisher case. If the financial institutions say we have 70,000 crores due, you can't turn around and say I have money recoverable in the global markets basis some arbitrations and disputes, and we will see what comes there until such time defer. No, that's not the jurisprudence. And finally, again, in defense of the old pre-IBC era, because that's the era I seem to know a little more about, it's not that the old Companies Act simply pushed companies into the whirlpool of insolvency. There is a provision, section 391, under which a company could always make an application for rehabilitation, for compromise and restructuring with its creditors, which could be done if a winding up petition was pending or even if it was not pending. And how many cases have we seen where courts have entertained 391 applications, convened meetings of banks, of unsecured creditors and others, of shareholders, and gotten schemes approved? I myself have done a number of such cases, involving in some cases tens of thousands of depositors, financial institutions, complex scenarios where assets had to be sold, money is recovered and paid off. Yes, you may say that is also in the nature of insolvency only, but I will say this, that those were all a lifeline to companies. They gave companies a chance to revive, and many of these were companies, I won't name names, but these were companies for whom more than the business, the legacy mattered. You didn't want a company to slip into liquidation because there was a stigma, and that stigma can sometimes spill over to the entire group company that you belong to. So therefore, friends, looked at from multiple perspectives, the judgment in Vidarbha, I don't think it necessarily takes you back to pre-IBC, but I think it takes you into realms that IBC had not contemplated. It has, in some ways, an effect of unsettling the balance between the role of the financial creditor and the operational creditor. It also, in some ways, conflates the discretion that the NCLT is to exercise under 7 and 9. And I'm pretty certain that sooner or later this judgment may be reconsidered on both these grounds. Over to you.
Thank you, sir. Now I have a few questions for you from the audience. The first question is that this judgment grants a wide discretionary power to the adjudicating authority, NCLT, to consider and admit Section 7 application. Wouldn't it lead to the admission of the Section 7 application on the subjectivity of the NCLT, which will lead to increase in litigation? There will be more and more appeals in the National Company Law.
Probably this question was asked before my talk. I have addressed it. Yes, it does create a newer discretion. And frankly, I feel all the facts were before the Honorable Supreme Court. The Supreme Court could itself have deferred the NCLT proceedings, exercising its powers under 142. But in the final paragraph, it remanded the matter to the NCLT. And I made an inquiry through one of my colleagues. That matter is still pending before NCLT. What is left then for the NCLT to decide? In light of all this, quite frankly speaking, the tenor of the judgment in Vidarbha is more in the nature of a 142 order, which you know is the extraordinary power of the Supreme Court, which no other court or tribunal enjoys. It's in the nature of staying a proceeding till such time the other case is decided. That, you see, when it's in 142, it's a constitutional power, then you're not really bound by 7 or 9 or pre-IBC or post-IBC. And it could have been done in that spirit. But to do it within the parameters of the code, I think, as the person has rightly asked, creates a new subjectivity or a discretion. Different benches of the NCLT may now see their power under 7 differently. Yes, not just multiplicity of litigation, it may lead to frustration of proceedings. It may cause inordinate delay, the sort of delay that the court was supposed to shelve. And yes, those would be the expected or unexpected outcomes of this judgment.
And next question. Sir, in para 17(9) of the judgment.
Why don't you let the folks ask the question? You will be asking the question.
Yes, sir. They cannot ask the questions as it's live on YouTube.
All right, go ahead.
I will have to read it to you. So, sir, according to para 79 of the judgment, it states that if the company is financially viable, the NCLT can reject the application or keep the application in abeyance. But the objective of IBC is to timely resolution of corporate debtor. So does it go against it? Does it defeat the legislative intent?
Sir, I already said, if a company is capable of rehabilitation or revival, has to be shown in real terms, right? Adjudicating authority can keep the admission in abeyance or even reject the application. In what circumstances is that? Where the facts and circumstances warrant. What facts and circumstances could those be in this context of a financial creditor's petition? You can turn around and then say COVID. COVID is also circumstance. But does that mean it leads to, in some way, rehabilitation or recovery of the company? Yes, some reasonable latitude is to be given, reasonable time to perhaps discharge the debt or to file your pleadings. You don't have to issue moratorium RP orders on day one. You can give some latitude. I grant that. But when you start getting into the ability to rehabilitate, as I said, then that money must be shown. Put the money down then. It's not that this 1400 crores was put down by Vidarbha. And you have to please remember this, friends, a judgment is a decision on its facts. The facts here was this 1470 crores or so was sub judice. If you're speaking of rehabilitation, revert to the principle that I told you from pickup, show commercial solvency. Do you have the money today? Can you write a check? If not to the financial institution, can you issue a guarantee or make a deposit with the registrar or the NCLT? If you can, you have the money. Then yes, discretion, maybe a few months to come up with a game plan. Why not? You don't have to be trigger happy to be admitting all cases. But if it's going to be this light at the end of the tunnel and nobody knows how long that tunnel is, then I'm afraid it goes into a tailspin.
So the last question.
Yeah.
The review application filed before the Supreme Court on the ground that certain observation made in the judgment could be interpreted in a manner that might be contrary to the aims and objects of the IBC and render the law infructuous. However, the Supreme Court, relying on the case of E.S. Krishnamurthy and others versus Bharat High-Tech Builders Private Limited, said that judgments should not be read as provision of statutes. Does it mean that the judgment in Vidarbha is not binding on the adjudicating
Vidarbha, not Vidarbha.
Vidarbha.
As far as I know, it is Vidarbha.
Vidarbha.
Sir, in fact, I just said that a judgment is not to be read as a statute. That's something the Supreme Court itself has said. A judgment is a judgment for a proposition it actually decides and not for what follows or flows from it. But at the same time, when principles are laid down, and principles are laid down by the Supreme Court, they do become binding under 141. So you can't say Vidarbha is on facts alone. It does have a spiraling legal effect. Now, while saying that in the review, in fact, ultimately the review was rejected. And the scope for review is limited. Now, if the Supreme Court wanted to roll back some observations in Vidarbha, it might have done so, but it didn't do it. Having not done so, it holds the field. And if I am appearing for a respondent, I know how I can use Vidarbha. I know how it can be used to advance the discretion or the jurisdiction of the NCLT, which may not have been hitherto the case, how it can be used to not rewrite, but reread and reapply the jurisdiction under 9. It doesn't begin and end with 7. It also goes into 9. So today, how an operational creditor may be able to take advantage of this judgment also becomes interesting. While it prejudices financial creditors, it suddenly advances operational creditors. Operational creditors were not privy to this litigation per se, right? So yes, the dismissal of the review with or without that observation, I think is clear that the judgment in Vidarbha continues to hold the field. It will be prone to use and abuse, I have no doubt. And at some point, it will find itself back in the Supreme Court when there may be a second look on it.
Now I hand over the space to Ayush for a vote of thanks.
Thank you, Amarpal. A very good evening to everyone. I, Ayush Pandey, on the behalf of whole Just Corpus team and Just Corpus Law Journal team, would like to express my sincere gratitude to Aditya sir for providing his precious time to us and for sharing the insightful and the knowledge on the particular topic. Hope our audience have learned a lot on this topic of Vidarbha and pre-independence era. I would like to thank to Aishwarya ma'am also for the smooth coordination for conducting of this program. And thanks to the 200 plus audience who have watched and viewed this session so far. On this Constitution Day, I am glad to say that on November 26th, and in this session also, it might be something like that Aditya sir has joined and like given the permission to conduct a session. We have increased and we have reached the limit of 25,000 followers on our LinkedIn page. So huge congratulations to everyone for supporting us, for joining in this channel. Thank you so much, sir, and thank you all the members of this chamber of Dr. Aditya Sondhi for the smooth coordination. Thank you, Amarpal, for hosting this session. Hope to see you soon in the future.
Thank you.